Good afternoon, everybody, and thank you for joining us today. It's me, David Hopkins. I'm here with Rebecca Drake. Kelly Stricklin-Coutinho and Santosh Carvalho are also online, joining us remotely. And we're going to discuss the Supreme Court's decision in Johnson and FirstRand, which was heard together with Hopcroft and Close Brothers and Wrench and FirstRand, the three conjoined appeals in Motor Finance Commission cases. The Supreme Court, as you'll all already know, allowed the lenders' appeals, and the FCA has announced over the weekend it is to consult on a compensation scheme. But the decision is of interest not only to those working in the motor finance sector, but the commercial litigation more generally, because the decision deals with, first of all, we're going to cover, if I could have the next slide, four topics. We're going to cover, first of all, whether the law should recognise a distinct tort of bribery. Second, if such a tort is recognised, the nature of the duty relationship that must exist for it to be engaged. Third, what level of disclosure will prevent liability for bribery from arising. And then finally, we're going to speak about what you should be thinking about following this judgment. There's a Q&A box in Zoom. Please do ask questions in there, and we will try to deal with those at the end of the session. But for now, I'm going to hand over to Santosh to tell you about what the Supreme Court has said on bribery.
Thank you very much, David. I'm going to confine myself to a few brief comments about the court's finding on two issues. Firstly, whether the tort of bribery does exist, and secondly, if it does, what's the normative justification for it, or in other words, should it exist? I think it's helpful, firstly, to remind ourselves what the court means by bribery in the context of civil law. On the facts of these appeals, the bribe in question was alleged to be the payment of a secret commission by the lender to the car dealer, who in turn facilitated the provision of finance to the consumer or the buyer. The court found there's three components to the tort of bribery. Firstly, the payer or the briber makes payment to an agent knowing that the agent is acting for another person with whom they're dealing. Second, there is knowledge of that. And then third, and this is insofar as it can be described as such, a defense or lack of, the payer or the briber fails to disclose to the other person with whom they're dealing that they've made such a payment to an agent. So the first question to address is, does the tort of bribery exist? And the court was quite clear on this. It does. Unsurprisingly, it was able to go through case law dating to the late 19th century. And in fact, there was a recent Supreme Court case in Mozambique. You have the citation in front of you on the screen that describes the same elements of the tort that the court went through here. I think what's more interesting for our purposes is the court defining a distinction between bribery and what we intuitively understand to be fraud. So linguistically, bribery would appear to be a species of fraud, but the court provided helpful clarification on the distinction as a legal matter. So as a legal wrong, there is a distinction. And I think the summary takeaway is that bribery, unlike fraud, does not require dishonesty on the part of the person paying the bribe or a dishonest intention in making such a bribe. Now, the court didn't use this language. It's my own taxonomy of thinking about bribery. I seem to conceptualize it now, having read the judgment a couple of times, as a strict liability tort in some ways, in that it's the making of the bribe that is intrinsically wrong. It doesn't matter what the intention of the person making the bribe was. That's not to say there's no defense to this tort of bribery. My colleague Rebecca Drake will speak about the level of disclosure that may negate the tort being established. But in terms of establishing the wrong per se, it's the act of making the bribe that's the evil or the mischief that the law is trying to cure. There are two other factors that's worthwhile laboring on. I think as I said earlier, the court emphasized the motive is irrelevant, dishonesty is irrelevant. So we're very much in that strict liability territory. And then the second point worth emphasizing is that the wrong is not confined to bribes made to an intermediary or an agent. It just so happened that the facts on the cases before, or the appeals before the court, were a tripartite relationship between dealer, lender, and borrower. But there may be a whole host of relationships in which the wrong might arise or this tort might arise. I'll say no more about the types of relationships in which this wrong might arise because my colleague David Hopkins will cover the types of relationships in which a tort of bribery might be established. The court also identified the remedy for bribery. So the innocent party can receive one of two remedies, and that's both jointly and severally against the agent and the briber, or the paying party of the bribe. The first is a restitutionary remedy. It's the recovery of the amount of the bribe that was paid, or recovery of damages in terms of the actual loss sustained by the person entering into the transaction. One point important to clarify at the outset is this does not mean when bringing proceedings, a remedy has to be chosen in advance. These are not a conflict of rights or an exercise of an inconsistent of rights. They can be pleaded in the alternative. So as an example, it's not like a choice between affirming a contract induced by fraud or avoiding it. As a matter of pleading, a claimant can bring both of those remedies in the alternative. If the claimant chooses the first remedy, recovery of the amount of bribe, they don't need to prove any loss. There is an irrebuttable presumption that the loss up to the amount of the bribe was in fact suffered. The rationalization or the justification of the court was treating the amount of the bribe as an inflation of the price of the contract or the transaction that was eventually entered into. And hence the remedy was described as restitutionary in nature. And this is quite a powerful remedy because the relationship between a contract and a bribe, or the price under a contract and a bribe, may be opaque, it may be indirect, and maybe even tangential. And if evidence were required to substantiate that, it might be quite difficult for a claimant to make such a claim. One question that the court did not address, so it remains a matter of live debate and therefore may show up in litigation, is where one bribe is paid for an introduction or a broking of an introduction towards multiple contracts or multiple transactions, the recovery of the amount of the bribe may not be adequate restitution because the inflation of price may run across several contracts or several transactions. In fact, in some cases, the inflation of the price may compound depending on the type of transaction in question. If the second remedy is chosen, that is damages, actual loss will require proving in the usual way. Another question worth pondering for a moment, and the court did not address this, it's a paragraph 190. The court made brief mention of a possible anomaly. Given that joint and several liability is available against the briber and the agent, when seeking restitutionary recovery of the amount of the bribe, theoretically anyway, we might have a scenario where the agent pays back the value of the bribe, and you might have the bribing party also paying back the value of the bribe. So curiously, the innocent party is in fact a better position than they would have been if the bribe had not been in the first place. Now, one view would say this is perfectly reasonable given the strong policy justifications, which I'll turn to in a second, which find that bribery is something the courts and the law must stamp out at every opportunity. And another view, this is just typical example of double recovery, which a court will throw out. We don't know which answer the court will go with, but it's notable that the court did make mention of the fact of the possibility of double recovery, which may indicate where the court is minded to head. There are also other remedies available against the briber. The noteworthy one is the right of rescission. So if a bribery claim was brought only in equity against the briber as a species of dishonest assistance, there would be an equitable right to rescission, meaning the contract could only be rescinded by an order of court. As to the secondary remedy, I'll just flag the fact that the principal also has remedies against the agent. And again, the proprietary remedies that arise, I'll say no more because that will turn on the type of relationship, which my colleague David Hopkins will cover. Turning to the other question, and at first blush, it might appear to be a rather abstract and philosophical question for the court. Should the tort of bribery exist? But the judgment did provide some valuable reasons for why it should, and the short answer was the court found it should exist. The first one is about the evil of bribery, and I've put two quotes, which were, the first one was cited by the court and the second from the court itself, and you can see what would be intuitive to most reasonable people, I think, the importance of stamping out undisclosed commissions or secret commissions because of the corrosive effect on commercial transactions. So far, so familiar. I think the more powerful justification lies in the doctrinal difference. So you can see I've put up a helpful comparator between the common law tort of bribery and the equitable claim in dishonest assistance. If the only way to bring a claim for bribery lay in equity, firstly, it would be one of accessorial liability, which in turn would affect the quantum of the loss, how evidence is to be provided. So evidence connecting the bribe to the actual loss suffered would be required. There'd be no presumption, irrebuttable or otherwise. And the extent of quantum, as I mentioned earlier, would only be insofar as the profits accrued by the bribing party, which again, depending on the nature of the transaction, may be very limited. So the power really in finding this tort of bribery to exist lies in the range of remedies that are available in law over and above what equity provides. I'll pause there and take the opportunity to hand over my colleague David Hopkins, who will cover the relationship required to establish the tort of bribery.
Thanks, Santosh. So the tort of bribery having been confirmed as existing, the next question for us is, what kind of relationship do you need in order to engage the relevant tort and seek to make good your claim? A little bit of revision, first of all, what a fiduciary duty is, and it's the classic statement from Lord Justice Millett in Bristol and West Building Society and Mothew. Distinguishing obligation of a fiduciary is the obligation of loyalty. That is almost simply a bit of etymology. Fiduciary, of course, coming from Latin for loyalty and trust. Lord Justice Millett also said that the core liability, the core obligation of loyalty, has several facets, and we're familiar with those, such as the duty to act in good faith, duty not to make a profit out of the trust, and not to place yourself in a position where your duty and interest conflict. Importantly, a fiduciary is not subject to fiduciary obligations because they're a fiduciary. Instead, once someone has undertaken to act for or on behalf of another in a manner which gives rise to fiduciary duties, that's what makes them a fiduciary. So fiduciary duties aren't imposed on persons because they're fiduciaries, rather because they've agreed and undertaken to act in circumstances which give rise to those duties, they become a fiduciary. And indeed that point was taken by the appellants in the Supreme Court, namely that equity does not impose fiduciary duties. A case which has bedeviled this particular area of the law for the last 4 years or so is the case of Wood from the Court of Appeal. In that case, David Richards, Lord Justice David Richards, as he then was, gave a quite lengthy judgment on the first issue of the type of relationship that was required to engage the law of bribery. And indeed, he toured the authorities and gave quite a careful and considered judgment. The conclusion he came to in that case, which was a unanimous one in the Court of Appeal, was that it didn't matter whether the duty was characterised as fiduciary, either in a loose sense or at all. Instead, all that was required was a duty to be impartial and to give disinterested advice, information or recommendations. And that was something slightly less, perhaps, than a fiduciary duty. In the Court of Appeal in the current case, Johnson and FirstRand, the Court of Appeal obviously was bound by Wood, and it considered the disinterested duty and fiduciary duty points separately. In the Court of Appeal, again, a unanimous judgment, the decision in Johnson was that a car dealer acting as a credit broker would be fixed with the disinterested duty if it was part of their role to provide information to lenders on the customer's behalf and to the customer about the available finance, but they couldn't act impartially because they had a financial incentive to put forward an offer from a particular lender, and they didn't make that lack of partiality clear to the consumer. Now, obviously, that would apply in many cases. In particular, in the motor finance sector, there were at least often agreements between lenders and dealers, either in the case of FirstRand in Johnson, to give FirstRand first refusal. So that was a financial incentive to put forward FirstRand, or indeed, in fact, actually, a contractual obligation to favour FirstRand, or perhaps a discretionary commission arrangement of the sort which existed, and I think Mr. Wrench's case in his second transaction. There, the lender and dealer have agreed, for example, that the dealer can set the interest rate, and the higher they set the interest rate, the more commission they will get, again giving a financial incentive to put forward a particular lender. So the Court of Appeal had held the dealers would be fixed with disinterested duty in that circumstance, and indeed found in all three cases that they were so fixed. Interestingly, the Court of Appeal also held that a fiduciary duty would necessarily arise from the finding of the disinterested duty. Now, that seemed to me to be slightly surprising, because the disinterested duty was apparently something slightly less than a fiduciary duty, but the Court of Appeal was finding, or did find, that it would arise necessarily once the disinterested duty was engaged. So in effect, making the imposition, as it were, of a fiduciary duty contingent only on the three factors we see on the screen. The Supreme Court, however, said that the Court of Appeal had proceeded on the basis it was unnecessary to show a fiduciary duty due to Wood. Supreme Court obviously not bound by Wood, and indeed the takeaway from this part of the judgment is Wood is no more. Despite David Richards', as I say, fairly careful, or at least it appeared, judgment, the Supreme Court held that the analysis in Wood was mistaken, and that a fiduciary duty is necessary to engage the law of bribery. The Supreme Court maintained the distinction between fiduciary duties and disinterested duties. Now, paragraph 201 specifically commented that they were a disinterested duty is different to a fiduciary duty of loyalty. Though there is the side comment that it may be difficult to conceive of circumstances in which such a contractual duty might arise without there also being a concurrent fiduciary duty. Confirming the end of Wood, what the Supreme Court said was that actually the authorities which David Richards had taken a tour through did all contain, or rather, in those cases, the agent was under a fiduciary duty. And while they might also have been under a duty to give disinterested advice, information, or recommendation, they were under the necessary fiduciary duty, and the Court of Appeal had gone wrong in Wood to find otherwise. As highlighted there, Supreme Court's view is that it would risk introducing confusion into commercial relationships if purely contractual duties, such as a disinterested duty, were thought to have the same consequences as fiduciary ones. And with that, I will hand over now to Rebecca on disclosure.
Thank you, David. I'm going to look at what level of disclosure will prevent the tort of bribery from arising. Now, paragraph 290 of the judgment said that since there was no finding of bribery, the question of the adequacy of the disclosures made to the customers would be best left to an occasion when it really mattered, which could make my section of the webinar very short. But given that the Supreme Court did discuss the law applying to bribery and disclosure, I think it's worth having a look at. So I'll start with the facts and the disclosure in each of the cases. So there were 3 customers, but 4 transactions. The first was Ms. Hopkins, 22-year-old, who bought a Fiat 500. The purchase price was £8,530. They're all priced around the same amount, with a commission of £183.26, so quite a small percentage of it. And that wasn't disclosed in any way notwithstanding the fact that Close Brothers then standard terms of business with brokers included an undertaking by the dealer that it had made all disclosures to the customer required by law, including as to commission. Mr. Wrench was the next one, and he bought two of the cars here. The first one was an Audi TT with a purchase price of £8,995 and a commission of £179.85. And his second car was a BMW 3 Series, slightly more expensive. That was £9,750 with a commission of £408.98. Now, he had in his agreements what the Supreme Court termed a commissions clause. So the credit agreement itself was accompanied by FirstRand's then standard terms and conditions. And clause 12.6 in the Audi TT case said a commission may be payable by us to the broker who introduced this transaction to us. This amount is available from the broker on request. Now, the only reference made to these standard terms and conditions in the credit agreement appears on its declarations page, where it says, the customer has had his or her attention drawn to the provisions of clause 10 over leaf. Now, there are two problems with that. As you may have noticed, firstly, it's not clause 10, it was clause 12.6. And secondly, it wasn't actually over leaf, but in a separate accompanying document. So that was the extent of the disclosure. And the same pretty much applied in the BMW 3 Series, except for the clause wasn't 12.6, it was 13.6, but still referred to clause 10. Interestingly, FirstRand's general terms issued to dealers said, you agree to disclose to the customer early in the sales process in relation to each regulated finance agreement that commission may be payable to you for acting as a credit broker and or credit intermediary. If requested to do so by the customer, you'll inform the customer of the amount of any commission and any other benefits payable by us to you. Now, at first instance, which is really all dealing with the facts, the judge found that although the commissions clause featured in the documents provided to Mr. Wrench was in there on both occasions, on neither occasion was it drawn to his attention, and he hadn't been told the amount of either commission. So that was the extent of it. Then we come on to the final case. Santosh, we could go back a slide, thank you. That's Johnson, Mr. Johnson, who bought a Suzuki Swift. And this was a substantially larger commission. So on a purchase price of £6,499, the commission was £1,650.95. There was a signed document prepared by the dealer which said, we do not charge a fee for handling your application for consumer credit, but we may receive a commission from the product provider. So this was the most extensive form of disclosure. So you can see them actually in ascending order of disclosure. We'll see what they found in the Court of Appeal next. The Court of Appeal found that for Hopcraft and both the Wrench vehicles, there was no or no sufficient disclosure of the commissions sufficient to avoid them being secret. Hopcraft, there was no disclosure at all. Wrench, there was minimal disclosure and not very accurate as well. It's saying that the disclosure clause is somewhere where it wasn't, the commissions clause was somewhere where it wasn't in fact. They found in relation to Mr. Johnson, there was sufficient partial disclosure to avoid the commission being a bribe, but insufficient disclosure to obtain informed consent. Now, when it went to the Supreme Court, as I said, they made no finding on the facts as to whether disclosure was sufficient, but they did discuss the law on disclosure in relation to bribery and said this. First of all, consent must be fully informed. There's no partial disclosure. The payer of the commission or the recipient, so either the finance provider or the dealer, whichever one is the subject of the claim, must prove that full disclosure was made. And that means that all material facts were disclosed. It's not merely enough to place the principal on inquiry. Now, what amounts to disclosure of all material facts or which facts are material depends on the circumstances of the particular case. And obviously the Supreme Court didn't deal with this in this case. So there's quite a lot of scope for future cases dealing with this issue. If we go back to the Court of Appeal, the Court of Appeal had held for the first time that a lesser requirement of disclosure applied for common law bribery than inequity following the decision in Herstanger. And the Supreme Court said they disagreed. Bribery at common law and inequity reflects the same concern, which is to ensure that an agent acts free from any conflict of interest, and therefore partial disclosure is not enough. Although that's the extent of disclosure relating to bribery, I'm going to consider Mr. Johnson's other claim, which was under section 140A of the Consumer Credit Act, because that's a section which deals with unfair relationships between creditors and debtors, and that's relevant to a lot of other claims as well. And the Supreme Court says this: the mere fact that there has been no disclosure of the commission or only partial disclosure won't necessarily suffice of itself to make the relationship between lender and customer unfair for the purposes of the Consumer Credit Act. It's a factor to be taken into account in the overall balancing exercise required under section 140A. However, they did say the fact that the undisclosed commission was so high, it was 10 times the commission in the other 3 cases, was a powerful indication that the relationship between Mr. Johnson and FirstRand was unfair. Now, interestingly, although the commission was £1,595.31 on a sales price of £6,499, actually of that, just over £1,500 was a loan, and the hire purchase agreement was only £4,804.39. The reason for that is that the car was priced higher than Glass's guide, and so Mr. Johnson wasn't allowed to take out finance for the full amount, so he had to get a loan to top it up. So he looked at it in that context. The commission is a very high proportion of the credit finance. They also said, following on from David's point, the fact that the commercial tie between the dealer and the bank was also not disclosed was another consideration highly material to the issue of the unfairness of the relationship. And the commercial tie between the finance company and the dealer there was that the finance company was given first refusal. The documents, on the other hand, were intended to create a false impression that the dealer was offering products from a panel and recommending one that best met the customer's individual requirements. Interestingly, the court said that Mr. Johnson displayed an almost willful disregard of the pre-contract agreement and the terms and conditions of the agreement, and that he said he simply hadn't read them. But the court still said it's unfair because they said he is not financially sophisticated, and actually no prominence had been given to the relevant statements. And given the size of the commission, you would expect them to have been given prominence for him to be told about it. It was pointed out that the amount of the commission was the additional amount of the loan, pretty much, that within about £10 that Mr. Johnson had to pay. So had that commission not existed, then the car wouldn't have been £1,500 more than the Glass's valuation. So I think that was very relevant in the court's mind. And they said particular attention should have been drawn to it because of that. And that's very much in contrast to the other 3 cases. And so accordingly, the court concluded that in Mr. Johnson's case, the lender should pay to him an amount equivalent to the commission with interest at a commercial rate from the date of the agreement. So not a huge amount from the court on disclosure related to bribery, but quite a lot more in relation to section 140A of the Consumer Credit Act. And now I'm going to pass on to Kelly, who's going to look at what implications this has for practitioners.
Brilliant. Thank you so much, Rebecca. Also, while we're having a momentary pausing point, of course, if everyone has any questions, please do pop them in our Q&A box at the bottom. So let's turn to what the key aspects are that have been announced already. So the FCA has already announced its compensation scheme, or to the extent that it's announced that there's going to be a consultation on it. So the announcement on the 3rd of August said that the FCA is going to consult on a motor finance compensation scheme. It's obviously not particularly surprising because that had been prefaced previously, but there is now a bit more meat on the bones in terms of what the consultation itself is going to contain. The stated aim is that this is going to be an industry-wide scheme, and The hope is that this will provide clarity and certainty to consumers, firms, and investors as quickly as possible. And there are essentially two core ideas being looked at here. On the one hand, being fair to consumers who have lost out, that's the FCA's wording, and on the other hand, ensuring the integrity of the motor finance market for future consumers. I'm going to turn now to process design. So this is around how this scheme might look. The FCA has said it's going to propose rules on how lenders should give effect to the scheme. Okay, so it's a lender-based scheme, but the FCA is setting out the overall and overarching principles. Some of those principles have already been explained. So they've talked, for example, about doing this in a way that's consistent, efficient, and fair, and that the lender should, in line with those principles, decide whether somebody is actually owed compensation and how much that compensation should be. And they've also made very clear that they're going to monitor the outcome of the scheme. There are a couple of references in what's been published recently around duty to monitor and so on. The consultation is also going to cover how firms should assess whether the relationships that we've been talking about between lender and borrower were unfair for the purposes of the scheme, and if so, as I say, what the compensation should be. There's been an indication as to timing, so they've said it will take time to establish a scheme, which is perhaps not surprising because the overarching principles have to be designed as well as how it's going to work for each of the lenders. But they have nonetheless indicated that they're hoping that payments will start to be made in 2026. Turning now to some of the factors in process design, they have identified quite helpfully some useful information around how this is supposed to work. So we've talked a little bit about some of these points which have come up in the judgment, but it is interesting to see how this is going to work in the context of a compensation scheme specifically, looking at some of the ones that have been identified already as going to be relevant for redress. For example, the size of the commission relative to the charge for credit, there's obviously going to need to be some kind of metric to make sure that this is being applied consistently across the various lenders who are going to operate this scheme. So I suspect this will be something which will be part of the consultation, and certainly something that people may wish to make some submissions on in that regard. Similarly, on some of the other areas around the characteristics, say, of the consumer and customer sophistication, it's going to be absolutely essential that that's also a principle which is applied consistently, and where I anticipate having some principles at the level of setting out the core principles of the scheme by the FCA will be very helpful. There might be some other ones which are a bit more straightforward, like the nature of the commission and so on. And finally, I would just say on the extent and manner of disclosure, as Rebecca's indicated, there are going to be some factual sensitivities, I think, around this. But obviously, there are some key examples that have been identified. And I think this is really something interesting around managing the cohort of people who have lost money and how they might be categorized. There might be something like you would have in group litigation where you might identify people who are within particular fact circumstances and so on. So as I say, there's a range of process design and factors that are being looked at, and it will be interesting to see how those are reflected in the consultation and then how those are ultimately reflected in the scheme itself. I'll turn now to some core principles which have been set out by the FCA already. So in June, the FCA set out some core principles as to how this might work. I've put them up on screen. I'm not going to read through all of them, but they are, in a sense, fairly straightforward. I would observe that there are, despite them being uncontroversial, there are probably some tensions between some of these principles. So, for example, if you want something done in a way which is simplistic and cost effective, that may mean that you do things in a way that perhaps isn't quite as nuanced as you might like, and that may have an impact on fairness, for example. So there may be some tensions between these principles, but nonetheless, they are a core set of principles which seem to work. And then turning now to the more detailed points that have been made in the most recent announcements. Generally, these statements which were made over the last weekend indicate similar sorts of points around fairness, timeliness, certainty, and so on. But a couple of additional points have crept in here. One about this being easy to participate in, and the express comment that there shouldn't be a need to use a claims management or law firm. And then the additional point also around this being an orderly and consistent process. I think that's quite important where you have a process where lenders or bodies are going to design and implement their scheme themselves, implementing the FCA's principles, to make sure that it is done in a consistent way across the different lenders is also quite significant. Okay, let's turn to some of the details of the consultation itself. So the consultation is going to be launched by early October, it said, and we know already some of the topics which are being consulted on. So it's already been said that discretionary commission arrangements will be part of the redress scheme, but there is an additional question about whether non-discretionary arrangements should also be included. There's a question around how redress will be calculated. There's also a question around whether there should be a de minimis threshold, given that some of these payments are quite modest. And then also a question in consultation around the interest rate and how this is going to work. So obviously the Supreme Court indicated that it should be interest on a compound basis. What has been looked at so far, it appears to be that the FCA is saying that they're looking at the average base rate for that year plus 1%, which overall works out to a simple interest at 3% per annum. Some further details on the consultation. So they're looking at the moment at arrangements and agreements which go back to 2007. The reason that that data has been picked is because it's consistent with the jurisdiction of the Financial Ombudsman. One really important point, and this I think is going to make all the difference as to how this plays out in future, is that they have said that they would want this to mean that consumers don't need to use other routes and therefore prevent large numbers of ongoing disputes in the courts. So it's not clear whether this would be a completely exclusive regime and therefore you're either in it or not in it, but it is important to understand how this works in practical terms. They're also consulting on whether it's an opt-in arrangement or an opt-out arrangement, and then some further detailed questions around the size of the commission and so on. Two quite important points if you're in a position of looking after some consumers. So consumers who are concerned have been told that they should complain now if they haven't yet done so, if they're concerned about commission that they and they think they've paid too much. And then the other point that's interesting is that where firms have received responses, they are being said now to produce their final response to those complaints by the 4th of December, but that is still subject to the timeline of the consultation and the timeline of when the process will start following the consultation. The FCA has also given some interesting advice to firms, which I think is worth bearing in mind. Firms will already, I'm sure, have this on their radar because many have already made provision for it. But the FCA has quite interestingly in its public statements now been very clear that obviously where there's prudential rules on maintaining adequate financial resources or firms with listed securities and their obligations to keep the market informed, each firm should now be making their own assessment of potential liabilities. And they've gone on to say that you should be taking into account a couple of things there. You should be looking at both the compensation itself and the administrative costs of the scheme, and then you should be thinking about making sufficient provision. So, as I say, many have already done that and will be very familiar with the ordinary process to do that. But given that the FCA have said it now, it's worth taking that extra point to consider. I'll turn now just to a couple of additional factors to consider. So I've already touched on the idea about whether or not this is going to be an exclusive jurisdiction type compensation scheme, or if there are going to be other ways in which consumers might try to give effect to their rights. One very interesting topic is whether or not there might be introduced retrospective legislation. So I'm sure you'll have seen the reporting around the possibility that the Treasury might introduce legislation to effectively nullify these claims and minimise the impact on the budget from this sort of matter. Obviously, the amounts at stake here, following from this judgment, are a little more modest than those initially thought potentially possible. Nonetheless, there are some challenges around retrospective legislation. It can be quite tricky to do this in a way that complies with all of the various elements of the law on retroactivity, particularly where it involves the cancellation of a right or a claim. So there are some things to navigate there. It's not yet clear whether that's something the government still wishes to pursue. Another interesting factor around how the scheme might work is whether and to the extent there's going to be a mechanism to challenge things. And I suspect there's probably some lessons to be learned from previous processes of this type. And then finally on this point, I would just add that there are probably some really important points around this process being designed well, given the scale of it and given that there is this structure of having an overarching set of rules as to how this is going to work, and then particular lenders who are going to create their compensation under this. There are going to be some points which will be important, which perhaps are a bit different to other circumstances, like, you know, considering wider aspects for the consumer, maybe some real clarity on things like whether a payment will be taxable. It probably wouldn't be, but nonetheless, it's very helpful to have a very clear indication so that that doesn't cause extra administrative burden. The accessibility of the process, given the types of litigants that might be involved here, particularly given the FCA have talked about there not being a need for there to be a claims management firm or a law firm involved. And also things like the fairness of the process if somebody's a late applicant and so on. So there's a number of things to be taken into account, which are around good process design, both at the level of the overarching rules, but then also the implementation of the scheme at root level. So just to summarize then, some key points I think probably for people to be looking at. Next, number one, looking at the consultation and responses to the consultation, where that's about design, which is going to affect what you're doing. Some points around the extent to which you need to consider making provision, what's appropriate and making that revision now. And then finally, as I say, if you are running your own scheme as a lender, you probably do want to think quite carefully now about structure, process design and so on, feed into the consultation process if it's appropriate on that. And as I say, if you're providing you comply with the overriding principles of what is being proposed, I would expect that what you can then do within your scheme is pretty much up to you. And of course, finally, mindful of the reporting and the monitoring that the FCA has indicated is going to be part of this scheme. Brilliant. So that was all I wanted to say on what comes next. I can see we are moving into our Q&A section and there might be some questions for us. So I'm going to turn back to my colleagues to see who would like to answer some questions.
I'm going to quickly pick up a question we've had, which is whether an insurance broker will owe a fiduciary duty post the Supreme Court's decision and therefore would still be at risk of secret commission claims. The decision doesn't prevent an insurance broker owing a fiduciary duty. There was a lot of discussion in the start of the decision. Quite interestingly, the Supreme Court spent quite a bit of time explaining the nature of the transaction which the car buyers were entering into, and about the fact that the car dealer, from the perspective of the consumer or objectively analysed, never really stepped out of the shoes as being a party on the other side of the transaction from which the consumer was buying the car. And I think that played quite heavily in the Supreme Court's reasoning, namely thinking about the fact that from the perspective of the consumer, objectively, you've gone to a car dealer to buy a car and they're the opposite party. They are an arm's length commercial party. It's a different scenario to what you're doing when you go to an insurance broker. So I don't think anything in the Supreme Court's decision would prevent a fiduciary duty arising. I'm afraid the answer is that one that everyone always loves hearing. It will depend on the facts of the case. But certainly it is possible for an insurance broker to owe their client a fiduciary duty, and nothing in Johnson will prevent that arising. And I'm afraid, therefore, well, it depends what side of the claim you're on, but there certainly is still a risk of a secret commission claim being brought against an insurance broker.
I was going to follow on from that point that David's saying they spent quite a lot of time explaining the relationship, and they compared, they gave a few analogies between a car dealer and other jobs. The one that stuck in my mind was a wine waiter, and they said if you go to a restaurant and you're asking the wine waiter, what wine should I have? You might give them some criteria, red, this particular area, but ultimately they're selling you wine, and they don't owe you a duty in relation to how they sell you that wine. So some other analogies, that's what I recall.
That's the one that stuck in my mind too.
If I can add to both of what you said, David and Rebecca, I think the one other relevant factor would be to consider closely the contractual arrangement that exists. The court was at pains in its analysis of the fiduciary duty to carefully analyze the authorities that dealt with finding such a duty where there was a pre-existing contract. And I'm paraphrasing. The fiduciary duty, in effect, has to fit within the contours of the pre-existing contractual or other duty relationship that exists. It's not to say a fiduciary relationship can't exist, but for anyone who's trying to establish a fiduciary relationship in such a broking relationship, they'd have to say that the wrong that's been committed or the duty that's been breached is something distinct from what was contractually agreed between the parties, because that would be the starting point for the court to make its analysis. The court was not categorical in analysing all the authorities that were relevant to a fiduciary duty arising where there's a contract, and there's an authority that's not referred to the court that remains good law. It's called Quantum Advisory and Quantum LLP, I think. If you search Quantum, you'll find the case, but that would go to, I think, the finding of the fiduciary duty as well.
We've got some more questions. First, how the judgment might impact energy broker commission claims. Well, the Supreme Court has got before it the appeal from the Court of Appeal in Expert Tooling and NG, and indeed the issues on which Expert Tooling was given permission to appeal to the Supreme Court were, first of all, was the Court of Appeal wrong to distinguish between a half-secret and a fully secret commission? So this judgment obviously will have quite a big impact on whether that issue even goes ahead, given the judgment has dealt with that question. More generally, the reasoning in the decision is, in my view, certainly of general applicability to brokers, while the relationship and the transaction won't be the same in each case. Clearly, the reasoning on secret commissions is relevant. So there'll be an impact in the sense that if you had another example, say a timeshare provider who was acting as a credit broker, for example, or we've already had insurance brokers, that reasoning will be applicable to them, and disinterested duty certainly won't be enough, and we won't be seeing people arguing for simply the fact that they were under a duty to provide disinterested advice being sufficient. So there will be an impact, namely the clarification on the relationship required for tort of bribery, and indeed the specific clarification on disclosure.
I can see there's another question there. Sorry, David.
Go ahead, Kelly. That was
Was that where you were going?
That was
fine. Okay,
no,
so
I was going to let you do it.
Thank you, that's kind. So there is a question here around how the FCA can curtail the rights of individuals to pursue a court remedy if they believe that they can do that faster than a redress scheme. So this is a really interesting point of principle. When you're looking at setting up some form of ADR, it's important, well, it's essential that parties are consenting to what's happening. So there was, as you'll all know, a case called Churchill a little while ago, which essentially provided that a court can order parties to use a method of ADR, but crucially, it's provided that their right of access to court is preserved. What that essentially means in practice is that methods of ADR, whether it's a compensation scheme or any other type of ADR, can be quite forcefully encouraged or ordered or required by a court to be used, but that it's essential that a party is entitled to use the court if that's what they want to do. So I think this is going to be quite interesting. So this is probably the first significant type of decision-making scheme since Churchill. So it'll be interesting to see what the mechanism is to admit people into this scheme and what retained right they have otherwise. One very pragmatic way of doing it is to make sure that if it's an opt-in scheme, people consent and do it on an opt-in basis. And when they have done so, that is a curtailment of their right of going to court because it is a final and binding decision that they're choosing to accept. So essentially, you contractually ensure that the party consents to a binding decision through the method of ADR, and the corollary of that is that your right to court is no longer there. So that's one way of doing things. Things might play out a little bit differently if it's an opt-out mechanism. But again, this is, I think, an interesting principle to test in light of the more recent jurisprudence and the changes to the CPR, where now the right for a court to order parties to use ADR is in the overriding objective, and there are cost sanctions and so on. And I think it'll be very interesting to see if a judge is faced with a claim, which is likely to be a relatively low value claim, whether they would look at it and say, the reality is there is an alternate process for this to be dealt with. And unless there are very good reasons why it shouldn't go through that process, I'm going to order you to try that first, or to go to that process. So that is a new aspect of how this scheme might work and might play out in light of changes recently to the CPR. David, did you have any different views on that? I'm conscious that we were both looking at
No, that was really interesting. Yeah, no, I think I can certainly see a judge wanting to tell someone that they ought to consider ADR. I mean, the only thing I'd add on the potential scheme is, seems to me that the level of commission is going to be a very obvious point for the FCA to make some rules around where it's effectively automatically unfair.
Yes.
Those of us slightly longer in the tooth like me will remember the scheme that was set up for interest rate hedging products sold to SMEs.
Yes.
And there were categories, essentially, if you had a structured collar, that was it. It was automatically deemed missold. And I can see here, possibly, for sake of argument, over 50% of the amount of credit as the commission, and that will be automatically considered unfair, things like that. So I think there'll be a lot of concentration on size of commission, as Rebecca was saying in the section on disclosure.
Yeah, and it's really interesting, isn't it? Because that's why I think where that idea of balance between simplicity and having certainty as to how the scheme works might be challenged by fairness. Because if you're very close to that borderline, maybe some of those other factors would come into play, which would mean that actually it falls on one side of the line rather than the other. And just referring to the point about IRHP work, I mean, of course, the idea that customer sophistication is being brought into this as well. I mean, there are obviously some lessons learned around how that worked under the IRHP work as well.
Absolutely. And then we've got a final question. Where there's been an omission of fiduciary duty in a commission claim, do we see this presenting some issues with relying on this decision? Certainly, if there's been an omission of fiduciary duty in acting for the claimant, then happy days. There'll be a question, of course, whether that admission is, and there always is when you get admissions in cases, whether it truly is a full admission of the sort that you can rely on, especially if it's pre-action, for example. Of course, the real difficulty with fiduciary duties in general is that, unfortunately, and it's often the case, and I'm guilty of it too, simply introducing the word fiduciary acts as a shortcut for the analysis. Once you've heard fiduciary duty, you go, right, we've got it. But it'll be necessary to ensure that you're pleading, if you're the claimant or if you're the defendant considering defending such a claim, that the fiduciary duty is sufficient to engage the law of bribery. So it'll be worth reviewing the section of the judgment on what nature of relationship is required quite closely. With that, I'm going to say we will wrap up. So thank you very much again to my fellow panelists, and thank you very much to all of you for attending. And hopefully we can now all get out in the sun and enjoy the rest of August without any more interruptions. Thank you again.